Good afternoon and welcome to the DC Court of Appeals. As a general reminder, we ask that you put your cell phones in mute so as not to disturb this afternoon's argument. Thank you. Mr. Harley, Vice President. And Mrs. Burnett, President. All rise. All persons have the business before the Honorable Associate Judges now residing in the District Court of Appeals, draw near and give your attention. God save the United States and its on report. This on report is now in session. Please be seated.
Good afternoon and welcome to the District of Columbia Court of Appeals. We have one case on the calendar this afternoon. It is 22 CV 595. FRENNIEJO D. NIXON versus Giovanni Ippolito et al. I know Ms. Denson, you'll be arguing first. You have your full time. We have, I believe, 5 counsel. And we've allocated you 25 minutes. Should I assume that you're each going to take 5 minutes? Is that correct?
Yes, Your Honor, and we propose proceeding in the order in which the vehicles were in the line, unless you have a different.
That's just fine. And I believe my colleagues and I all have helpful graphics from our law clerks showing us the order of the vehicles. So that works very well. All right, well, we'll get started and go from here. If you could also let me know, Ms. Denson, once you introduce yourself for the record, how much time you'd like for rebuttal.
Thank you.
Thank you.
I would like to reserve 6 minutes for rebuttal, please, Your Honors. Great.
Whenever you're ready.
Thank you, Your Honors. If it may please the court, and as Your Honors and everyone present today are aware, a motion for summary judgment is only proper when no material fact is in dispute. The court takes these appeals de novo, and the plaintiff, as is stated in defendant's briefs, are required to show a causal connection between the incident and the injuries. Given that in this specific matter, there are several theories as to negligence, this case should not be dismissed as a matter of law. A jury is allowed under the rules and the law and permitted to draw any reasonable inference from all evidence, direct or circumstantial. A review of all the defendant's states of facts gives rise to this, as all of them contradict each other with regard to facts, who was where, how many hits they felt, whether someone was stopped or whether someone was going.
Well, counsel, if I could stop you there, could
Yes.
you clarify for me a little bit where you would draw that line of reasonable on the type of inference a jury can draw? Like, there's a lot of disputed fact here. It seems, I'll agree with you, but it seemed to me that the trial court was saying that at some point here, there has to be a theory that's enough for the jury to do more than kind of guess and say, I like this witness and I don't like this witness. Where would you draw the line?
So I think that what that rests on, something we touched on in our brief, is that this was a rear end collision. And as we stated in our brief, the case law says there's a rebuttable presumption there. When a party proves the basic facts giving rise to that, we satisfy that presumption. Hazmino, Fisher, and Warwick all say that. Now, defendant Attile specifically testified that he was hit in the rear. He also testified to damage to his vehicle that resulted as a result of this crash. Plaintiff Nixon testified that they were hit in the rear. There is a dispute between the two of them, whether or not he was moving or proceeding forward at the time. Under the law, Mr. White, who was the vehicle directly behind defendant Attile, has a duty not to hit the car in front. He says that he blacked out and doesn't remember if he did. He does know for a fact that he was hit pretty significantly in the rear by defendant Deere, who has conceded that fact.
And so is the fact that this involved rear ending and multiple rear endings, is it your theory that that's what separates this from our case law that says the mere fact of an accident doesn't give rise to negligence?
Correct. There are numerous facts here that a jury could draw an inference. For example, going back to what I was saying, the fact that there's damage to the back of defendant Attile's vehicle. Defendant White has testified that they were hit. They don't know if they hit the vehicle in front of them. Defendant Deere has testified, yes, I hit defendant White, then I was hit in the rear. My car was still touching defendant White's vehicle when I was hit in the rear. I'm not sure if it hit the car in front. I think the jury could draw a reference to was damage to the front vehicle. Yes, defendant White's vehicle impacted the back of defendant Attile's vehicle.
Okay, but so on a variation of, sorry to cut you off, variation on Judge Howard's question though, and accepting that you are saying that that rear ending is a critical piece of this, but on more going to the summary judgment question, at what point does the non-moving party have to do something beyond say, I don't know what the heck happened, and that creates a disputed issue of material fact versus here are the disputed issues of material fact that preclude summary judgment. And if it's more the latter, what did you do to meet that requirement?
With respect, Your Honor, we don't think that this is a simple situation where it's just, I don't know what happened. Ms. Nixon does not know the order of the impacts. She has testified pretty definitively their vehicle was impacted. That we know. There was testimony, there was damage to the rear of defendant Attile's vehicle. That we know. We know that defendant White was struck. I do not think that that is a reach, and that is just a leap for a jury to say, yes, these specific facts could give rise to negligence actually happening. We think that's sufficient in and of itself. We have other defendants, specifically defendant Deere, admitting to not paying attention, and several defendants saying that the vehicles in front of them stopped suddenly and they impacted them. Under the rules and the statutes, one's required to keep a sufficient following distance behind the vehicle in front of them. Suffice to say that if you have a series of people where someone stopped in front of them suddenly and there was not enough time for them to brake and avoid hitting them, and there was an impact, there could be an inference drawn that they were following too closely or they weren't paying full time and attention to the road.
So under your theory,
sorry.
if a jury felt like we cannot say that it is more likely than not which car out of these three following did the actual hit. You would argue that liability applies to all three because there's a presumption that or you would see the jury could find that they were not allowing sufficient space.
Well, our position on that would be that this is a question for the jury. We're not saying that surviving this motion for summary judgment automatically means that we win and we've defeated liability. That's not our requirement when it comes to a motion for summary judgment standard. What we think is that a jury could look at all the facts, all the testimony, including from the brother of defendant IPPOLITO, Salvador, who testified that he saw the chain of events, and make a conclusion as to who they might think were responsible. They could very well find that one person, multiple people, or no one was in fact at fault in this incident. Our requirement is not to prove the specific facts and prove everything to withstand a motion for summary judgment. Additionally, if we're saying that a person who was rear-ended or in a crash has to prove every specific fact and every specific detail in something, we'd have a lot of cases getting dismissed. This is a frequent situation that happens where someone gets hit. Oh, I was hit. I may not know what was there because I wasn't looking. My client was a passenger. She wasn't a driver. So the fact, sorry, Your Honor.
No worries, counsel. I wonder, because we're going to have 5 lawyers getting up after you to
Yes.
tell us why they think there's no material issue of disputed fact with respect to their particular client. I wonder if it would be helpful for you to go through each defendant and tell us why you think that there is a disputed issue of fact with respect to each defendant. So that we have that as a baseline before we hear from your friends on the other side.
Okay, and if I'm going to do it like they want it and take it in order of how they were given the diagrams. So we have defendant Attile, who is the front vehicle that my client is a passenger in. Defendant Attile testifies that the car in front of him, random car, cut him off. He had to stop suddenly. He decreased his speed significantly. He felt an impact in the rear. Ms. Nixon testifies that that they were stopped at the time. We think that's a dispute of material facts. Defendant White, via other counsels, argue that there's no evidence whatsoever that defendant White was negligent and that our theories are speculation. The fact that we have 2 people testifying there was an impact, and the fact that there was damage to the rear of the
Sorry,
vehicle.
if I could slow you down just a
Yes,
little bit,
sorry.
and I know you're trying to get through a lot in a short period of time, but rest assured, we'll give you a little bit of extra time if need be. So that as far as your, to the extent Mr. Attile is saying, I was not negligent,
Mhm.
you would say that is disputed because
He says that he said he slowed down and he was able to slow down. Okay. Mr. White, defendant White, has testified that the car in front of him, which was defendant Attile, stopped suddenly, that it was
I see.
something that
Thank
came
you.
sharply. We think that gives rise to negligence on defendant White, going back to the presumption that we stated before with a rear end collision and being able to
I
keep
thought you were
distance.
just telling me, I apologize, but
Attile and
my-
White kind of go hand in hand.
Right, but if you could keep their negligence, well, maybe you're saying their negligence is
Similar.
concomitant. But you're saying there is some evidence possibly that Mr. Attile was negligent in driving because he decreased speed too suddenly such that someone had to hit him from behind.
Correct.
Okay.
Um,
And then you're moving on to Mr. White. And
Correct.
explaining why you think the evidence shows at least a dispute as to why he could be negligent.
correct.
Okay.
The fact that he testified that the vehicles in front of him were moving, that the car in front of him stopped and instantaneously there was a hit. The fact that there is such a short period of time, we think is a fact that gives rise to potential negligence. We think that is a material fact with regard to this.
Was it undisputed that, I think you would say it's not undisputed, but was it undisputed that he was hit by Mr. Deere first?
So I think Mr. White's testimony would lend to he was hit first, but he says he does not know. He insists he did not hit defendant Attile. However, there's damage and there's testimony that he was hit. So if you're reading it in favorable to defendant White, it was after his hit to
There's
Attile would have been after.
I thought there was testimony that Ms. Nixon's vehicle Mr. Attile and Ms. Nixon's vehicle is only hit once.
That was what Mr. Attile says. He definitely remembers one, could have been two. That was his specific testimony, in his
Okay,
deposition.
Ms. Nixon testifies
No,
one,
Mr. Attile,
right?
Attile,
But
Ms.
does,
Nixon says one hit is what she
says
felt.
one hit. And
Yes.
so if Mr. White's vehicle hits Ms. Nixon's vehicle, I'm trying to figure out what that means, but anyway.
So looking at the deposition testimony, defendant Deere says similar to what defendant White says, that the vehicle in front of him, which was defendant White, stopped suddenly, slowed down. He concedes he was looking to check and see what was on his right because he wanted to get over. He didn't recognize seeing the car before him ahead of time. When he turned back too late, tries to stop, was unable to. So that would also lend to defendant White potentially stopping too soon, not keeping a good following distance in that situation.
And you just
Well,
mentioned Mr. Deere. Am I correct that you raised a race ipsa loquitur argument with respect to him as well?
We did raise the race ipsa loquitur argument with regard to Mr. Deere and all the defendants. We did, despite defense
It was
counsel's
not just
claims.
limited to Mr. Deere. It was raised with respect to all the defendants?
We did in our, I believe it's in our reply, we address it. Defense said that we didn't address it at all prior to the motion of reconsideration. We actually did. We addressed it in our initial opposition, and then we again stated it in our reply.
I'm sorry, just to clarify, in Superior Court, you raised a race ipsa argument as to all defendants.
In our, give me 1 second, Your Honor. In our motion to oppose initially in Circuit Court, excuse me, Superior Court.
But I don't mean to cut you off while you're looking, but you responded to each defendant's motion for summary judgment individually,
Mhm.
right?
Yes,
So it's possible, I'm not saying it's the case, but it's possible that you raised res ipsa in those in an opposition only once or twice, not, you didn't file a single opposition.
correct.
So I guess our question is, I think I only saw it in the response to Mr. Deere's motion for summary judgment, but you can correct me if I'm wrong.
No, defendant Deere, actually, I remember seeing it from defendant IPPOLITO's opposition where they spoke specifically about res ipsa loquitur. That's what I.
But
most
I'm talking about
remember.
your client.
Right.
Raising res ipsa as a theory
Yes, against defendant Deere.
only as to defendant Deere.
I believe in our initial oppositions, we might have done that. I don't, sorry.
And I mean, now, are you only positing it as a theory on appeal with respect to Mr. Deere then still?
So we addressed it in our reply as to everyone because of the way that the defense motion was positioned. And how they stated that there was no, and we had raised it for the first time. But yes, the section, if you look in our reply, is specifically to defendant Deere.
Okay.
Yes. Did Your Honor want me to continue through each defendant and negligence
Please.
or talk about the race ipsa loquitur?
Carry on.
All right.
Thanks.
With regard to defendant Deere and whether or not there are material facts in dispute, defendant Deere argues that any impact after White to Attile is irrelevant. Not sure why, and in fact, the court didn't give any discussion or reference to the testimony of Salvatore Ippolito, who's the brother, who says in his testimony, he saw all of it, that the large SUV who was identified as defendant Deere started the chain of events. There were about 5 or 6 hits as what he saw, and he was actually a person not involving in that.
I thought that, and I mean, maybe this only underscores what you're saying, maybe that's your response, but I thought it was unclear from the testimony whether the SUV that brother Ippolito was referring to was Mr. Deere's car or a different car.
No, it was defendant Deere's vehicle,
How do we
because there
know
was a
that?
specific question of whether or not the SUV that they saw impact, he said it was large. They asked if it was your brother's vehicle, and they said, no, it was another large vehicle, and it was in front of.
But it could have been a
Defendant
completely different vehicle,
Ippolito.
right?
That's the only other SUV involved in this collision, and
mean,
he
like-
saw the collision. of
Okay,
all
I
the
thought, okay,
vehicles.
I thought it was a car that may have caused all of this and then got away, like, but.
That's not the way that I read the evidence, that it's a car that was in the middle of the collisions, is how I read it and how I understand it with the testimony. We would argue that with regard to material facts and a rise of negligence on defendant Deere, he testified, as I alluded to earlier, that he looked to the side, he was not looking forward, not paying attention. When he turned back, not enough time for him to stop, he slams into the back of defendant White. It is a pretty significant hit, looking at everything that is involved. The fact that there was a significant hit, the fact that he concedes the fact that he was not looking, was not paying attention, and that he simply didn't have time before he hit, we think gives rise to that, especially since he said he hits defendant White and then he's hit by defendant IPPOLITO after that. Defendant IPPOLITO, there are several things they're not, he's not completely clear on. Your honors will bear with me. When looking to defendant IPPOLITO's actual statement of facts, there's disputes within that. There are conflicting testimonies within all of them. There is testimony that Mr. White's vehicle, the impact between White and Attile occurred before, and then there's testimony it might have occurred after. On the other hand, Appellee D states.
Where's the testimony that it might have occurred after?
So in the statement of facts, when you go through, see which one specifically one. In the review of the statement of facts, it would be in Appellee National Generals and Geico's briefs. They allege that the testimony
briefs-
is that Appellee Deers, sorry.
Briefs aren't evidence. I'm
Okay.
looking for, evidence that was before the Superior Court.
They argue that was the testimony that was given by
By whom?
by defendant Deer.
I thought Mr. Deere testified at the appendix, page 508, that he hit the second car, Mr. White's car, before Mr. IPPOLITO's car crashed.
Agreed. That's
into
how he
him.
testified. That's what I'm saying.
Right.
There's,
Well,
sorry.
and then I think Mr. Attile testifies that he sees more than two impacts behind him after his car has been hit. So I'm trying to see where the evidence is that Mr. IPPOLITO had any causation, hasn't had any causal impact on this chain reaction. Right, if Mr. Attile and Ms. Nixon's car has already been hit, what are you relying on there to create a disputed issue of fact?
So I think where we think that lies is that there's still a dispute into the fact as when what hit occurred. So defendant IPPOLITO concedes that he rear-ended Appellee Deer's vehicle, and Appellee Deer says that he hit defendant White's vehicle. Defendant IPPOLITO, however, is unable to say whether or not there were impacts before him prior to his impact into defendant Deer.
Right, I understand that he's unable to say, but don't you need testimony that contradicts the testimony that Mr. Deer hits Mr. White before he's hit by Mr. IPPOLITO?
To establish there might have been negligence on the part of defendant IPPOLITO.
Correct.
I think the fact that we go back to that same rebuttable presumption, you are behind a vehicle, you have the responsibility of following at a safe distance. If you're also saying, which again is
I
another
understand the
position.
presumption. I think I'm not making my question clear.
I apologize, Your Honor.
If Ms. Nixon and Mr. Attile's car has already been hit, then I'm not sure what work the presumption would do for you.
That's the problem. We don't know that, Your Honor.
Well,
But-
but I guess, sorry.
No, go ahead.
I mean, it would cut against causation, right? So no matter, so then at that point, one of the elements you would have to prove, if it's undisputed that Mr. Deer had already hit Mr. White before Mr. IPPOLITO hit Mr. Deer, and there was only one impact to your client's car, the car your client was in,
Mhm.
then whether or not Mr. Ippolito was breached a duty not to hit Mr. Deere's car. My clerk offered to bring matchbox so cars up here. Then
Not to make light of this,
No,
but
no,
the
I
visual is
understand.
sometimes helpful.
I
right,
understand.
then even if there was negligence in hitting Mr. Deere's car by Mr. Ippolito, there wouldn't have been causation with respect to your client, I guess is the point. As a matter of law, there wouldn't have been causation as to your client. That's the question.
Okay, so if we are looking at, and it would be easier with matchbox cars, if we're looking at defendant Ippolito, then we have Deere, White, and Attila. If the theory that a jury putting all the evidence together, weighing credibility, doing all of that, thinks, okay, Ippolito is Deere, Ippolito hits Deere, Deere goes forward, and then White pushes forward into Attila. In other words, Ippolito is the start of a chain of events of hitting cars because they weren't paying attention. If that's something, that will be a theory of negligence against defendant Ippolito.
Right,
Again-
that would be, do you have any evidence that that happened, right? Because it seems like the evidence that I saw, and I could very well be missing something, is that Mr. Deere is saying, I hit White first before I got hit.
We would
And
argue,
is there anything on the other side of the ledger to say, no, it happened in a different way? And what I hear you saying is it could have happened in a different way, or no one knows that it didn't happen in a different way. But I'm not sure that that's enough to survive summary judgment.
I think the significance is of the significance of the hit between Deere and White. This was not a tap. This is a pretty significant hit. And Ippolito testified he did not see any impacts in front of him before that happened. That is the direct car in front of him. It was not a tap. It is a pretty significant hit. We think that could be someone saying, yes, that happened after. He didn't hear any kind of impact that significant. This is not the impact between White and Attila, which was testified to as not being as hard as the hit that White testified he felt.
Can I ask you one question somewhat
Yes, Your
related?
Honor.
Your client testified that there was only one impact on the car she was in. Mr. Attila was a little more equivocal on that, perhaps. Can your client use as a disputed issue of material fact whether there were one or two impacts on the car she was in?
Use that to establish negligence against.
Well, no, just use that as a dispute, cite to that as a disputed issue of material fact in light of her direct testimony.
I would think so, given that you have defendant White that is testifying that their testimony is, I definitely did not hit the vehicle in front of me before I was impacted. He was very clear in saying that, but I do not know, since I blacked out, if I hit the car in front of me after. So if they're feeling one or two hits, I think that might be something that could be, if he felt two hits, it may be that he didn't realize he hit him.
I mean, I guess I'm asking you, are you accepting the fact that there could have been two hits on the car that your client was in, given that she testified that there was only one?
I don't know. I don't understand what you meant by accepting.
Right.
But I think my client's testifying as credibly as she can. She remembers having one hit.
Okay, all right. It's not a great question. Sorry.
Sorry.
So do you have anything else for us at the moment, counsel? Otherwise, I might let you get back up on rebuttal, but if you'd like to take a minute or two just to wrap up, and then we'll hear from opposing counsel.
I'll save for rebuttal, Your Honor.
Thank you.
Thank you, Your Honors.
Going to my chart here, so I think I'm ready, but if you'll introduce yourself for the record.
Good afternoon, Your Honors. Diana Coburn in the law offices of Frank Daly on behalf of Appellee Gustave Attila. Your Honors, it appears that the main theory of liability against Mr. Attila is that he potentially would have stopped more suddenly than could be expected, and that would have triggered Mr. White to impact him. That goes against the actual testimony of Mr. Attili himself, where he testified that he slowed down from about 55 to about 40 miles per hour. And that testimony is consistent with Mr. White, who as you know, was operating the vehicle directly behind Mr. Attili and testified that Mr. Attili's vehicle was slowing down as, quote, was slowing down as I'm slowing down along with traffic.
But Ms. Nixon testified that Mr. Attili did come to a complete stop, right?
That was Ms. Nixon's testimony. But however, even if viewing that in the light most favorable to Ms. Nixon, there is still no genuine dispute of material fact, as to Mr. Attili, because Mr. White testified that he could still see the rear tires of Mr. Attili's car when Mr. White's vehicle was impacted from
Well,
behind.
just because it's 2 against 1 doesn't mean that there's not a genuine issue of disputed fact, right? If Ms. Nixon says we came to a complete stop,
Well,
the fact that Mr. Attili and Mr. White are giving testimony that's consistent doesn't mean that we discount her testimony at this stage, right?
Well, the dispute would have to be as to causation, whether even if Mr. Attili had come to a complete stop, wasn't moving at all, whether that led Mr. White's vehicle to impact Mr. Attili's vehicle. And Mr. White's testimony is that he could still see that there was still distance between his vehicle and Mr. Attili's.
So you don't think an inference could be drawn from the fact that the car stopped suddenly, if that's what happened, that then Mr. White, whether or not he remembers it that way, I mean, he blacks out, that he hit Mr. Attili's vehicle for that reason?
I think based on the testimony that we have and the competing theories that the entire incident was triggered by all the cars that followed Mr. White's vehicle, I think
What do you think that the competing theories has to do with it, right?
that
Isn't Ms. Nixon entitled to competing theories at this point? Or do you think she has to settle on one?
Well, I think that she just has to present something more than speculation that it could have happened in any number of these ways, but there's no actual evidence of negligence against Mr. Attili. That even if he had slowed down, that actually triggered the.
She testifies that he came to a complete stop on a highway.
Yes, her testimony is in conflict with Mr. Attili's and Mr. White's as to
So you would
whether they
agree that
stopped or not.
that testimony, that evidence had to be weighed to come to a determination, right?
Well, again, I would just believe that still doesn't present a genuine dispute as to causation, as to
At the summary judgment stage, the judge is not supposed to be weighing evidence and making determinations there, right? Just supposed to be determining that there is no conflict on any material fact.
Correct, Your Honor, but that fact has to be material. Again, if there is no causation evidence that Mr. Attili's actions triggered Mr. White or any of the vehicles behind him to collide into the rear of his vehicle, then it's not a material dispute, it's just a dispute. And that would still entitle Mr. Attili to summary judgment at that stage. And then very briefly, the appellant's brief as to Mr. Attili also cites to the testimony by Mr. Salvatore Ippolito, the brother of appellee Ippolito, saying that Mr. Ippolito had noted this is on the last page of their brief, that the SUV that you saw, the initial SUV that he saw was the one that was first in line that triggered the whole accident. And I would just note that the vehicle that Mr. Attili was operating was a sedan, not an SUV. So Mr. Ippolito's testimony that he saw an SUV or a large truck, a large vehicle up ahead that triggered the whole incident, in no way lends any credence to the theory that that my client's vehicle was the one that stopped suddenly or that had triggered the whole incident. And with that, I see my time is up. Thank you, Your Honors.
Thank you very much.
Afternoon, Your Honor, Article 3 to 4, Appellee National General Assurance Company we're in this case as an uninsured motorist carrier, and we're entitled to all of Mr. White's defenses in this matter. And I think your court has hit upon a very key issue for this hearing, and that is, what is a fact connected with a possibility? With regard to Mr. White is quite clear and testified that he did not strike the vehicle the plaintiff was in until after he was hit. He said that I was hit from the rear. I had not hit any other vehicle before then. Mr. Deere, in his testimony, also admitted that he hit the white vehicle before the white vehicle had struck the vehicle the plaintiff was in. Those are the established material facts. The fact that Mr. Atteel says there may have been, and that there was one impact between White and the vehicle plaintiff was in. White says he doesn't know about a frontal impact because he had been blacked out when he was hit from the rear. Plaintiff herself says, I felt one impact. The driver of her car says there was definitely one impact. I don't know if there was more. That's not a disputed material fact. That is a material fact and a possibility. So when we're looking at this case on appeal, I think we have to look at the fact that there was one impact between White and the plaintiff's vehicle, and that impact occurred after Mr. White's vehicle was rear-ended by Mr. Deere's vehicle.
And so are you, is Mr. White no longer adhering to his testimony that he never hit anybody?
That's not material as far as did he hit the vehicle in front of him.
Right.
The evidence, there is disputed evidence that there was an impact, and National General will concede there was an impact to the rear of the Atteel vehicle. There is evidence that it was the white vehicle that struck the Atteel vehicle in the rear, but that's not material to this motion because this has to do with proving causation and or negligence of White. Where is White's negligence here? He testified he was behind the vehicle plaintiff was in. That vehicle, they were at the same approximate speeds. That vehicle began to slow.
You said what's the testimony that they were at the same approximate speeds?
It is.
If Mr. Atteel is testifying that he was slowing down, and Ms. Nixon says we were at a complete stop.
Correct.
And there's testimony that Mr. White is driving at 55 miles an hour. Or am I just taking evidence from different periods of time?
That would be my position, Your Honor.
But is that clear?
I'm going to make it clear right now.
Great.
In appellate page or appendix page 618, Mr. White describes that when he was asked, did the speed of your vehicle change when the car in front of you suddenly slowed down? Answer, yes, because if I kept at my speed, I would have collided with that vehicle. Question, do you know or can you approximate how fast you were going before the car in front of you slowed down? Answer, 54, 55, the speed limit. Question, how slow did you have to go after the car in front of you slowed down? Answer, it must have been about the speed to drop roughly 10, 15 miles per hour, probably. They slowed down. Question, and after the vehicle had suddenly slowed, were you going about 40 miles an hour? Answer, about 30. Question, okay. Answer, decreasing. Question, were you continuing to slow when you got hit in the rear below 30 miles per hour? Answer, yes. Skip a line, I'm going with the flow of traffic. So to not hit the car in front.
But you still have Ms. Nixon's testimony that they had come to a complete stop.
And
so that all makes sense if Mr. Attile's car is slowed down, but not at a stop. But if Mr. Attile's car is at a complete halt, then don't you think there's an inference of negligence from still driving 30 or 40 miles an hour?
No, absolutely not, because he testifies and Mr. Deere agrees he struck Mr. White before any impact. So whether the plaintiff's car was moving slowly or dead stop.
Again, I'm getting back to the 2 out of 3. I don't see how that just erases a potential material dispute of fact, right?
No, Your Honor,
look, there's so many different ways that this cookie could crumble, right? But it's not our job at the moment to figure out which way it did. And it wasn't the trial judge's job to do that either. And so if there is some evidence that the car in front had stopped and that Mr. White's car was still going 30 or 40 miles an hour at the time that it stopped, forget about what everybody else is doing, or when those cars hit each other, there could be negligence on the part of your client, which then leads to this presumption of the following car being negligent, right? I mean, we're at the summary judgment stage,
I
right?
understand, Your Honor, and I disagree on one key.
Okay,
It doesn't matter as to Mr. White and his negligence, how fast the car in front of him was going.
it doesn't matter.
No, ma'am, it's not material because before he could either come to a stop himself or run into the rear of that car all on his own, he was struck from the rear by Mr. Deere.
That is what he says.
And Mr. Deere says, and no one says different.
Okay, I see what you're saying, but are you saying that as a matter of law, if Mr. White was pushed into Miss Nixon's car, that precludes negligence liability?
Yes, I am, Your Honor. That breaks the proximate cause chain because.
But could he have, if someone is following too closely
Mhm.
and then is pushed into the car in front of them, are they still not negligent?
Correct, because that is the proximate cause. We don't know what would have happened if Mr. Deere never hit Mr. White. We have no idea, and nor could a jury figure out whether Mr. White would have been able to stop in time.
Counsel, before you go too far down this line, I would like to clarify, you were on a line before where you had started on page 618 of the appendix, and it looked like you were going to 619.
Yes, sir.
Are you giving up this piece on 619 where White is saying that he slowed down, he's moving at the other car's pace, and he says the vehicle ahead was almost stopped, still
Correct.
moving, but almost at a stop, and he was matching that?
I'm not, that is what it says. Yes, sir.
So are you giving that up and now saying that's not really relevant to it? Because it seemed to be the argument you were making initially, and now your argument seems to have shifted to me
Okay.
because he was struck, none of that's relevant anymore.
That was my argument all along. This is illustrating because the question was he, his speed had come up. And I was saying this testimony supports the fact that he was keeping pace with the car in front of him. But I still say once he's hit from Deere, as a matter of law, and the proximate cause chain is broken, and the only way to reestablish that on these facts would be for the jury to guess or speculate as to would have White hit plaintiff had he not been hit in the rear by Deere. And there is no way a jury could make that conclusion without guesswork or speculation. And the court did the proper thing and dismissed the case against Mr. White on those facts.
Can I ask you a question? And maybe this is extra record, and if it is, just tell me and you won't answer the question. But are there ways to determine outside of testimony when impacts happened? For example, if airbags were triggered?
You're referring to like black boxes on the vehicle?
I mean, anything like, would it be possible for Ms. Nixon at trial to go and say, no, now I can prove that Mr. White hit me before Mr. Deere hit Mr. White?
I don't believe there is, Your Honor. That has to come from, short of discovering a video, I suppose, that shows this accident, that there is no evidence of. Then yes, I guess I don't think you can do that. I think it has to come down, in this case, to the witness's testimony. We have testimony from not only Mr. White, but from Mr. Deere.
Counsel,
Yes.
your argument then is that because we can't say definitively that your client was the proximate cause, that you win on summary judgment?
Yes, Your Honor. Yes.
But proximate cause is generally a jury question, no?
Not when the only way to get that proximate cause conclusion is through guesswork and speculation. And that's if we look at what limited facts we have here on the appellate record, there is no disputing it. Could have happened another way, I suppose, but the only evidence we have is that Deere hit, and I don't know, I'm not even getting to why Deere hit White in the rear. Deere hit White in the rear first, and then White's vehicle impacted the car in front of him.
You think we can say as a matter of law that that's what happened? You think that Did the trial judge in this case make actual findings of fact, of undisputed fact, say, these are the undisputed facts here?
I don't know if the court in its opinion.
Right, because that's usually what happens
Yeah.
on summary judgment, is that a
And-
trial judge says, I've been given all these undisputed facts, I've been given filings by the parties to say this is what is actually disputed. This is what I say is undisputed, and this is what is disputed if I think that there's anything disputed. We didn't see that in the trial judge's order in this case.
What I recall seeing in the order, and I don't have that right in front of me, is that there were findings of fact as to the sequencing of cars. There were discussions of some of the evidence that was presented. And I believe the court's finding was based on the fact that no one could say that any of the particular defendants were negligent based on these facts, that it would resorting to guesswork and speculation as to Mr. White. Would Mr. White have hit the car in front of him if he had not been hit in the rear? And if he had been hit in the rear, which the evidence is clear, that is the only fact, or the fact, that supports the fact that a jury could not say without guessing or speculating, this accident would have happened without that rear impact as the proximate cause.
Well, we have a presumption when the car's rear-ended that there's likely some negligence, or there's a presumption involved in this. And then if we assume for the sake of argument that the res ipsa loquitur argument is preserved, didn't the trial court kind of flip things around? Isn't that normally at that point, not that the arguments change that much, but it would be the potentially liable defendants sorting out the liability amongst themselves there, as opposed to getting summary judgment entirely against the plaintiff?
I don't agree, and that's because the presumption of the negligence of a rear-end driver in a collision only applies in the absence of emergency or unusual conditions. Now, as to Mr. White, the plaintiff is not entitled to a presumption of negligence of that rear-end impact because there is established fact that he was struck in the rear before he hit the car in front of him. No one, the plaintiff has not come up with any evidence. None of the other co-defendants have come up with any evidence that it happened any other way. In fact, Mr. Deere and Mr. White are singular in that, and they both agree to that. So the whole idea of the res judicata presumption of rear-end accident does not apply to Mr. White in this case.
Counsel?
Yes, ma'am.
We are out of time.
Thank you. I
So we'll let
appreciate
you
your
sit
time.
down and we'll hear from another one of your colleagues. Thank you very much for your argument.
Good afternoon, members of the bench. My name is Jack Lapidus. I'm here for GEICA, and our position, another provider, and our positions are very similar to that of Mr. Carita. Our negligence or exposure or potential liability flows from the any alleged negligence by Mr. White in this case. In this case, the court properly found that there was no basis to support a claim of negligence against Mr. White, and I think correctly entered summary judgment on behalf of both GEICO and National General here. We've talked and the questions have gone on, but I think a lot of the issues here, it's theories versus evidence. And in this case, there's no evidence, no factual dispute with respect to Mr. White's negligence. And I think Mr. Carita touched on that. White was behind Mr. Etele, moving along with traffic. He slowed when Mr. Etele slowed, and Mr. Etele's testimony was it was just a tap on the brake. But he was slowing. However, he slowed. The testimony, which was read, and I think Judge Howard also talked about some of it. He was slowing with traffic ahead, whatever that speed was. And I think also more importantly, Mr. White also testified. This is not the appendix on page 613 and 614 and 615 that there was enough space.
Yeah, I mean, you're confusing me again, because you're talking about the space now and the slowing down and all of that. And it seemed like your colleague suggested that none of that was relevant anymore because Mr. White was hit first by Mr. Deere. So it doesn't matter what speed they were going and how close he was following. So, and there is a disputed issue of material fact, as I think maybe as to whether Mr. Attil stopped short or slowed down and what the distance was.
Your Honor, I don't disagree with Mr. Creed as far as whether it mattered. I agree with his position. It doesn't matter, but I'm saying in addition, there is no evidence, there's no factual dispute of negligence in the first place as to Mr. White. You know, the evidence is he was following, he was moving at or below the speed limit, moving along with traffic. He slowed and with traffic, and he would have had enough opportunity to stop, but for getting hit from behind. That's his testimony at 6:13. So there's no, I guess, there's no factual evidence to support any finding of speed, improper distance, inattentiveness, or anything short of speculation based on the record that we have before it. So nothing to support a claim of negligence. And then the second point would be, it wouldn't even matter if there were, because you got hit from the rear. But I think you don't even have to get to that point. I think you can stop or start, however you want to phrase it, with the fact that there is no evidence in the record of negligence, a fact, as opposed to a theory or speculation as to what might happen. And I think that if you look at some of the cases, the Evans v. Byers, for instance, talks about you have to have some, or frankly, all of the cases, the fact that the accident alone isn't enough. Evans v. Byers.
That is generally true, but I just keep coming back to Ms. Nixon's testimony that they were at a full stop, and we said in Warwick versus Walker, where a lawfully stopped vehicle is struck by another car from the rear, there is a rebuttable presumption that the approaching vehicle was negligently operated.
But in this instance, you also have factual testimony that he had enough distance to stop. When you look at the cases cited on the rebuttable presumption, Fisher v. Best, for instance, in that case, the plaintiff, I'm sorry, not the plaintiff, the defendant said, admitted there was unrebutted admission offered into evidence that I took my eyes off the road. Everything in that case pointed to the only explanation was negligence by the defendant. Same thing in Warwick v. Walker. In that case, there's a two vehicle accident. The only suggestion of negligence that's inferred from that is that it was from the following driver.
Counsel, if this went to a jury, wouldn't the jury have a right to say, we don't believe him with regard to he was following at a safe distance, et cetera? Doesn't this imply, I get what you're saying, it's unrebutted, that the judge had to make some sort of credibility finding to get to that being an undisputed fact?
Well, no, I don't think he made a credibility finding. I think there's no disputed fact. I mean, the standard is there a factual issue in dispute? If it's just the jury can always disbelieve any witness, and if that's the standard for summary judgment, then there's there's almost no summary judgment, except maybe in contract cases where you look at a plain contract. So I don't think the case law that has found summary judgment in various torts.
So how does he know that it's a safe distance?
The same way any other witness testifies that they were behind us and he looked too close. It's their testimony. In the what was it? The King case, the front driver talked about, I think it was 9 feet, she looked back and I think it was 9 feet or maybe 9 yards. I forget what the specific testimony was, but it's based on the observations and testimony is how it comes up.
Thank you, counsel.
Thank you, Your Honor.
Thank you, Your Honor. This is Elaine Thompson. And first, I want to thank you for letting me appear remotely for this argument. I represent FRENNIEJO, was the third vehicle involved in the accident. And first, let me address the Brezza argument. I don't believe it was in the opposition to the motion for summary judgment. I believe the first time it was raised was on reconsideration. for that motion. And the judge in Superior Court didn't mention the res ipsa argument in the initial order. So I don't.
If it was raised on reconsideration, excuse me,
I believe.
that adequately preserves it for our review at this juncture, no?
All right.
And
Joe-
counsel, sorry, I want to, but I also want to question your premise. I'm looking at appendix page 72. I think this is the renumbered appendix. Ms. Nixon cites the case Sullivan v. Snyder, which says that res ipsa can be sufficient to prove negligence. Now, she doesn't develop the argument with respect to specific facts in the record later. Is that your argument? Or because I don't think you could maintain an argument that she never mentioned res ipsa loquitur.
I mean, the phrase was not mentioned in the opposition. Maybe Snyder discusses it, but it was not specifically raised by name as a theory they were proceeding under. So I didn't address it in the reply. But also as to res ipsa, I don't think we have a situation where you can point to exclusive control or joint control by any defendant. The theory is that these 4 drivers jointly caused this accident. Obviously, there's individual drivers and there's no joint control of the vehicles at issue. The Greek v. Udis case I cited discuss a elevator company that was repairing elevators in a hotel which controlled the elevators. In that case, both parties had joint control of the elevator. And
Counsel, I'm sorry to interrupt, but if you agree that it's undisputed, and maybe you don't, but it's undisputed that your client hit Mr. White first, and Mr. White hit Ms. Nixon second, and Mr. IPPOLITO hit your client at some point thereafter, or at least after your client hit Mr. White, then isn't that enough to establish negligence on the part of your client related to this? Sorry, go ahead.
the negligence, but not under a theory of res ipsa. I don't believe
Put aside
that-
res ipsa for a second. If there is some evidence, it doesn't even have to be undisputed, right? That your client hit Mr. White first. Doesn't that keep him in this case
No, I don't.
at
believe
this
so.
juncture?
I don't believe so at this juncture. There's no evidence that the impact between Mr. Deere and Mr. White pushed him forward. All the witnesses and parties who testified said, I don't know, or I didn't see that the impact between Mr. Deere and Mr. White pushed the white vehicle forward into the Atelier VT.
Right, there's no direct evidence of that, but there's evidence that could be collected, right? That if your client hit the Deere car, your client is Mr. Deere, sorry. If your client hit the white vehicle and then, and there was only one collision, right? And there is some testimony that there's only one collision. And, I think one could draw the inference that your client was the source of that one collision with the Atelier Nixon vehicle.
I don't believe
A
so.
fact finder could, right? At least at this stage. I don't know how
But
you could say
it would-
otherwise.
It would be a total guess, based on the testimony we have.
So
That,
is your theory, counsel, that,
purely speculation.
counsel,
Mhm.
so then the real problem I'm having with this theory of it is if any accident, car or otherwise, is sufficiently complex, if there are multiple potential causes for it, that means that a plaintiff's just out of luck. If they don't know themselves, if they couldn't observe everything going on to know what specifically injured them.
No, but there must be some evidence of proximate cause. Some evidence, however slight, there must be something. And here the plaintiff or appellant has presented nothing to suggest that Mr. Deere's impact with Mr. White approximately caused her injuries. As everyone has said, the mere happening of the accident is not enough to survive summary judgment. In addition,
So counsel, you're at the 5 minutes of your time. If I can give you a quick minute to wrap up if you would like that.
1 minute is at page 675.
You've turned your mouth away from the microphone, so it's hard to hear you. Sorry.
675 of the appendix, Mr. Let's see, Salvatore Ippolito clearly says the large SUV is not the Deere vehicle. If you look at that, Mr. Ippolito doesn't even recall what Mr. Deere was driving at the time. So I wanted to make that clear, and I'll conclude my argument. Thank you.
Thank you. Thank you for appearing remotely.
May it please the court, I'm Jennifer Servery. I'm with Wilson Forte and I represent the appellees Anna Chayaka, who's been dismissed from this case by order back in January, and Giovanni Ippolito. We're the last car, so I'll try not to repeat what everybody else said at this point. Ms. Nixon cannot meet her burden of proof against Mr. Ippolito. What's been presented in the testimony provides no causal link to the impact that she feels. And I think that that's what's important. They're only conclusory assertions, which the court has held is insufficient to use for motions for summary judgment. And that's Nixon versus Washington Metro Transit. It's undisputed. She feels one impact by her own testimony. That's the impact that matters. She doesn't know who hits her. She doesn't interact with anybody at the scene. She doesn't get out. She sues her own driver because she doesn't know how the accident happened. And that's the reality, is that she's asking for all of it right now because, and that's, I think, the problem that the court had on the lower level in looking at this and talking about some of these impacts, because even circumstantially, while I understood Judge Howard's question, when there's multiple people and you don't know how it happens, there is still a burden that plaintiff has to hit against each and every defendant.
That
to
burden is
identify
borne
them.
at trial. The only reason that burden could be not, I mean, the only reason that burden has shifted here was, I mean, is because your client, I mean, all of the defendants moved for summary judgment. So
Sure.
at this point, the burden's actually on you, right?
Based on the evidence, I believe the court is to view it in light of the non-moving party. Yes, I agree with that completely.
I mean, I think it's just, it's not helpful to say that she sued a lot of people because she personally didn't know what happened, right? So I think maybe we'd prefer to hear from you about why your client, why you think there's no disputed issue of fact with respect
Sure.
to your client.
And that's understandable. Essentially, there's no dispute in any causal link that Mr. Ippolito hits Mr. Deere by his own testimony. he doesn't see any subsequent impacts. He doesn't know of any subsequent impacts. According to Mr. Deere, he's hit from behind after he hits Mr. White. He knows of nothing subsequent. Mr. White reports one impact from behind. Mr. Atteel is certain of one impact from behind, and Ms. Nixon asserts there's one impact. I don't think the causal link in the evidence presented at this point, even viewed in favor of Ms. Nixon, warrants any finding of negligence against Mr. Ippolito.
When you say it like that, we might agree, but I thought that there was some testimony that I didn't understand Mr. Atteel's testimony to be so unequivocal that there was one impact.
Mr. Atteel is unequivocal that there is definitely one impact from behind. I think when he goes back and forth, he says that there may have been a subsequent one. He's not really sure. And that's where he leaves, I believe, his testimony.
And then there's also testimony from Mr. Deere that when at the moment he was struck from the rear, he was still in contact with the sedan in front of him.
Correct. But he is sure that it is consequential. I think his testimony is that it's instant. So he hits Mr. White and they're close in time, but they're still sequential in nature. And he knows of no other impacts or whether that goes forward or not. So there's still evidence missing there to causally link and then assert a legal responsibility on my client. And that would be our position. Ultimately, that there's no evidence for liability to be asserted against Mr. Ippolito as a matter of law. Essentially, what's been presented are just theories of it. And I understand, but it's that one impact that matters ultimately. And a breach of duty, which clearly happens because we rear end Mr. Deere by our own admission, without a causal connection, can't produce that legal responsibility. And so, although there are various theories presented, there's no genuine issue to be disputed or reviewed by the trial court at that point. And so we would ask for the judgment to be affirmed of the lower court.
Thank you, counsel.
Thank you.
So I hope I haven't miscounted. I think we've heard from 5 appellees. Great. All right. We'll hear again from Ms. Denson.
Thank you.
I will try to work quickly and backwards this time, going from Jennifer all the way up. Addressing council statement, we're not asking for it all, your honors. I think you were correct in saying that that's a burden for trial. There are theories that could be found as to negligence against several, if not all of these defendants. With regard to what was testified to on behalf of defendant Deere, the Greek case is not analogous to this case at all. It's about an elevator case where there is a dispute over who had control.
Counsel, can I pinpoint you to some things that might be most helpful, at least to me? I don't want to speak for everyone.
Sorry.
No, I'm not suggesting you were off on a tangent, but is it undisputed that, do you agree that it's undisputed that Mr. Deere hit Mr. White before Mr. White hit the car your client was in?
I don't agree that that's undisputed.
Okay, where is have you pointed to record evidence that
The
calls that
fact
into
that-
dispute?
Sorry, Your Honor, I didn't mean to cut you off. The fact that defendant Ippolito said that they didn't see or hear any impacts in front of them prior to their impact with the rear of defendant Deere.
Okay. And do you agree that it's undisputed, or are you maintaining that it's disputed that there were potentially more than one impact on the car your client was in?
I think that is undisputed because defendant Attila does say that he knows for certain there was one, there may have been another. Our client says that they only felt one impact. I do not think, as counsel said, that it was its definitive statement, from defendant Attila, that it was definitely one, and no, it absolutely wasn't another one. He also testified that he thinks he saw other impacts after his impact in his rear view.
Okay, that's all if you wanted to get back to your.
Thank you. We do want to say that the case that they cite for Greet is not analogous to this case. It's specifically regarding the malfunction of an elevator and who had control over that. In this specific instance, each defendant had specific control over their vehicle. No one is saying they didn't have control over their vehicle. So we think that that is not an analogous case. Your Honors also touched on a point that with regard to the res ipsa loquitur, that was part of our argument, is that the judge, the Superior Court level, did not address that either in their initial or the reconsideration motion. And to go back to your question earlier, we did raise that issue of res ipsa loquitur specifically with in our initial oppositions to Deere, Attila, and Geico. We do cite those specific pages where we did it in our reply in response. So it would be appendix page 72, opposition to appellee Deere's motion for summary judgment, appendix 84, opposition to appellee Attila's motion for summary judgment, and appendix at page 97 for opposition to appellee Geico's motion for summary judgment. So contrary to their statement, we did raise it as to Deere prior. The court does not, in fact, Your Honor asked if the court listed off facts that were disputed, undisputed in their initial order and decision. They do not do that. We also think that Defendant White's statement that it's not material if Defendant White is hit without if Defendant White hit Attila, or if Defendant White was hit without a hit to Attila from White, there is no hit. Nixon, there's no injury in that situation. No one has argued or said that any vehicle other than Defendant White would have been the vehicle to strike Defendant Attila. Defendant Deere, in fact, says he doesn't know if Defendant White was stopped or moving at the time that he hit him. And Defendant White says that, does not say that he had enough distance to stop. He never says that he was stopped, contrary to what the arguments that defense made.
But do you disagree that if, and I know you said it was disputed, if Mr. Deere hit Mr. White first and then Mr. White hit Ms. Nixon, that no matter what happened due to Mr. Attila, that legally breaks the negligence liability chain?
We don't think so with regard specifically to Defendant White, because he testifies that after he gets hit, his vehicle doesn't move at all, that he hits the brake and his vehicle does not move. He says it more than once, which would suggest that his vehicle was so close as to have impacted. And he never testifies that he was completely
Right, but
stopped.
so you're saying that you're saying that it's disputed. I'm saying that if it is undisputed, if it appears to us to be
Okay.
undisputed from the record that Mr. Deere hit Mr. White first and then Mr. White hit your client's car, that there would be no negligence liability as a matter of law.
With regard to Defendant White, as
Yeah,
in Defendant
correct.
Deere pushed Defendant White and
Correct.
Defendant Attila. We would concede that point, Your Honor, yes.
Okay.
Mr. Defendant White actually proves our point and says it more than once. It comes down to the testimony and the weight of evidence, which is what defense wants everybody to do here. He said specifically, we have no video. So that's the only way we know definitively, specifically what happened in this chain of events. And we don't have that. And that's an impossible standard to impose. And that's not the standard for motion for summary judgment. And going to the last point I wanted to make with regard to their arguments, there was a question of whether or not the SUV that Mr. Salvatore Ippolito testified to, whether or not that was belonging to Defendant Deere. Actually, there was a request for judicial notice to be taken that Defendant Deere's vehicle was the first SUV, which would make it the vehicle that Mr. Ippolito saw in the chain of events. As I said earlier, we don't have to prove definitively what happened. We think there is enough evidence here. There are disputes with regard to material facts that make this an issue for the jury. Reinstatement of this case does not mean that we win. It doesn't mean that we get a verdict against every single defendant out there. We may very well, if this is reinstated, go to trial and lose as to liability with regard to every single defendant or only one defendant. At a minimum, to dismiss every single defendant because we've dismissed one, we think is not appropriate as a matter of law. Simply because the defendants can't agree or because they give conflicting self-serving testimony doesn't make it immaterial and doesn't mean that we haven't met our burden in this situation. We would again rest and rely on the appendixes and our brief and our reply and ask that you please reinstate this case as to all defendants.
Thank you, counsel.
Thank you, Your
Thanks
Honors.
to everyone who appeared in court today. We appreciate your time. The case will be submitted and this court stands adjourned.
All right. This court is now adjourned.